Assalamualaikum warahmatullahi wabarakatuh. Om Swastiastu, Namo Buddhaya, dan salam kebajikan. Hi everyone. First of all, I would like to say thank you for the opportunity given by my niece. Here, I will discuss about the case execution of fiduciary guarantees on movable property problems and solutions in legal practice. Presented by Movable. Before I explain about the case, let me introduce myself first. My name is Lydia Felicia Manopo, and currently I am a student of University of Dimulga Kota Movable in major business law, and my lecturer in subject English language is Miss Reza Aprilia. Okay, here we discuss about introduction. In modern economic life, the need for financing has become an inseparable part of community activities. Both individuals and business entities want form of finances, and that is widely used in finances with collateral, where the debtor submits collateral to the creditors as a form of responsibility for his debt. In the context of civil law in Indonesia, material collateral has an important role in providing legal certainty and protection for the parties. One of the most widely used types of collateral in Indonesia is fiduciary collateral, which is regulated in Law Number 42 of 1999 concerning fiduciary collateral. Fiduciary is the transfer of ownership rights of an object through trust from the fiduciary giver to the fiduciary recipient, but the object remains in the control of the fiduciary giver. This collateral is generally used in motor vehicle financing transactions, electronic devices, and other movable goods, especially in the consumer finances and leasing sectors. Next, the definition of fiduciary law. The word fiduciary comes from Latin fiduciary, which is the legal dictionary is defined as trust. In Indonesian, the term fiduciary refers to the transfer of ownership right based on the principle of trust, while in Dutch legal terminology, it is known as fiduciary property overdraft. The root word fides also means trust. The meaning of trust here indicates that the guarantor has confidence that the transfer of ownership is not intended to provide full ownership to the decretors. If the obligations in the main fiduciary agreement have been fulfilled or paid off, then the ownership of the collateral will return to the guarantor. Marhainis, in his book on civil law relating to fiduciary guarantee law, terms in agreement on trust, namely from the words fiduciary property of a drafter, abbreviated as FIO, which is also known as the term transfer of ownership rights to trust. According to him, the term fiduciary property overdraft FIO, this often occurs in society, especially in the banking world, where a customer asks for credit from a bank, and what is used as collateral is movable goods, but the collateral is not handed over by the owner of the goods to the lender or bank, but is still controlled and used by the owner. Here, conflicts harm fiduciary guarantee execution and their solution in legal practice. PT-MPM Finance as a creditor carried out direct execution of the fiduciary collateral object without going through a court process. This action was taken after the debtor was deemed to be in default, whereas execution was directly by the creditors without a court decision that gave rise to a legal dispute. The debtor sued for the action, referring to the decision of the Constitutional Court MK number 18 PUU XVI 2019, which stipulates that the execution of fiduciary collateral must go through a court process unless the debtor voluntarily surrenders the collateral object. The Rokan Hill District Court in its decision said the PT-MPM Finance action were unlawful. The court emphasizes that the execution of fiduciary collateral must be carried out in accordance with applicable legal procedures, namely through the courts, unless there is an agreement and voluntary surrender from the debtor. And here, solution in fiduciary property law practice. First, complication with the Constitutional Court decision. Creditor must comply with the Constitutional Court decision number 18 PUU XVI 2019, which requires the execution of fiduciary guarantees to be carried out through the courts unless the debtor voluntarily surrenders the collateral object. Second, inclusion of a default clause. In a fiduciary agreement, it is important to include a clause explaining that condition of default and the execution procedure, including the debtor's agreement to voluntarily surrender the collateral object in the event of a default. Third, registration of fiduciary guarantee. In order to have executorial power, fiduciary guarantees must be registered in accordance with Law Number 42 of 1999 concerning fiduciary guarantees. Fourth, settlement through the courts. If the debtor refuses to hand over the collateral object, the creditor must submit an execution application through the courts to obtain a legally binding decision. Fifth, improving legal understanding. Creditors and debtors need to improve their understanding of their respective rights and obligations in fiduciary agreements as well as execution procedures in accordance with applicable laws. The conclusion. Fiduciary guarantee is a form of material guarantee that provides legal protection for creditors, for receivables given to debtors based on truth, where ownership of the object remains in the hands of the debtor as long as the obligation has not been paid off. Law Number 42 of 1999 concerning fiduciary guarantee explicitly regulates the execution mechanisms in the event of default by the debtors, including through executorial implementation, public occasion, or underhand sale. The main problem in the practice of fiduciary execution is the unilateral execution by creditors without proper legal procedures, which often ignores the debtor rights. That's all from my explanation about this cause. Thank you for watching and see you next time.